October, Lordship.
Service has been affected on the other side?
Yes. Lordship, maybe we should mention one extension of interim order. The CRAN application has been filed within time, Lordship, before expiry of the interim order, and service has also been affected. Gratefully, Your Lordship.
We are for the husband. They are sending the order of interim maintenance.
What is this? Motion?
Yes, sir.
No,
Lordship, may I permitted to mention one criminal division matter, Lordship, for inclusion in the list.
Madam, they have been provided to mention one CRR matter. It's your motion for inclusion in the list.
Chalo. This matter is appearing under the heading to be mentioned. Inadvertent typographic error has crept into order dated 18 November 2025 in the cause title, mentioning the name of the petitioner as Prosenjit Sutradhar instead of Wangdi Tamang. No, বানানটা দেখে নেবেন WANGDITAMANG. This. The name of the petitioner in the said order be read as Wangdi Tamang instead of Prosenjit Sutradhar. The order dated, the aforesaid order is modified to the above extent. The other portions of the order shall remain unaltered. This order shall form part of order dated 18 November 2025. Next.
Name of the council of the state,
This matter is appearing under the heading to be mentioned. Inadvertent typographical error has crept into order dated 18 November 2025, mentioning the name of the learned advocates for the state as Obhijit Sarkar, Mr. Obhijit Sarkar and Mr. Dhiman Sil. Inverted comma মধ্যে রাখবেন instead of Mr. Niloy Chakraborty, learned APP and Mr. Saurabh Ganguly. Let the names of learned advocates such and such be read instead of অমুক, হ্যাঁ বাকিটা সেম
না তোমার নাম না
Service to the VG.
This matter is relates to POCSO law. Lordship, the allegation is that the complainant's daughter, in the evening time,
Lordship, yesterday, earlier occasion, they have paid for time as per their,
They had.
let me finish, let me finish.
One
Each and every day, dear Lordship, we are carrying the CD. Lordship, it's a huge amount of money. To, 70 lakhs, more than 70 lakhs.
Supplementary affidavit.
They assured that they will be
Where is
for
the
that.
supplementary affidavit?
Lordship, we filed them.
Misapproved amounting to rupees
Not
more than 75 lakhs.
Don't file it.
And they have got one order not to take any quasi measure. Taking that advantage, now they are playing with the prosecution along with the Lordship. So, earlier occasion, they have also stated that they will file this or
They
that.
had taken the time due to.
No, no,
submitting
I
the report,
I
Lordship.
paid for.
They had taken
No.
that for this time.
You have filed a report.
Tomorrow.
Report is ready. Report. The seeks accommodate and submit detailed status report.
Lordship, Nathan has been fixed on 23rd December 25 for IS report. She has not filed your Lordship, and this person not cooperate the investigation. I have even called him,
Lordship,
but he didn't turn up. He didn't
we
meet the
filed a
IO.
supplementary affidavit disclosing everything, Lordship. Just give this out, Paswa, Lordship, there are.
For direction, he did not appear before the concern.
Lordship, I appeared before the concern IO, Lordship.
Why?
Thereafter, did not comply my notice, Lordship.
Yes.
2 days I
Actually,
appeared before him,
actually,
Lordship.
False allegation, the prosecution.
Due to filing one writ petition against this investigating officer, Lordship, I
Lordship,
Where is your report?
regarding the report sheets, I was said that no, actually after getting that order, they didn't return attend the IO, not to appear for the.
Lordship,
Let me finish. Lordship, he didn't appear before the concern as per direction of the Honorable High Court. It's a violation of the landed court order. And thereafter, Lordship, the date has been fixed, the trial court that has been fixed on 23rd December 25, your Lordship. So unless and until he appeared before the concerned IO, the case cannot be progressed. Even IO cannot file the charge sheet, your Lordship. But taking that advantage not to take any coercive measure, now they are playing this on us. He said that he had been to the IO, but IO said I called him. He said no, there is no such a. He
So
never
why-
appeared before that.
Why the IO is not filing any report stating the fact that he is not attending in terms of the order of this court? The court has granted him a liberty that you appear before the IO and join the investigation. And also call for a report, detailed report from the state. On the last date, this report was not there. You sought for time to file the report. That report has not yet been filed by the IO. If he is not attending, let it be in writing that he is not attending. Huh? দুটোর সময় 1 second up.
Yes, I will call him.
11:30. Get the supplementary affidavit 11:30. You are for whom?
But allocation under section 300.
Earlier application rejected.
No, it's for. And it's page 9. I manage now. Page 9.
Next.
Item 6. Lordship, I'm petitioner praying for a short pass over my land and clear on his way to court.
Item 7.
I am appearing for the state. But on earlier occasion, when interim protection was given to the petitioner, that is on 10th of September 2025. Kindly see the order. And state was directed to produce the status report. This is the status report.
Paying for short pass or not. Connecting at the down is then another four. Paying for short pass or not.
This is the status.
The conducting advocate is engaged in Calcutta court lordship. For that reason, kindly make it talk to the lordship. Will you appear by tomorrow? He just call me and instruct me to take the lordship in this matter.
Ask him to appear only.
Kindly make it not possible, lordship.
Ask him to appear.
Okay.
He has joined investigation.
But this is the 35(3) notice, my lord. Yes, my lord. He has joined the investigation. He has complied with the notice served by the investigation officer.
Next up. Where is he? Where is the learned advocate?
Calling you exactly or virtual.
तो पास करो it report पे to state के दिए नहीं.
I have as a copy, my lord. My lord, oh, take.
As of now, you keep the report. Take it up after.
Yes, my lord.
Item 8. Worship, I am the petition of hearing for transaction. And to defect.
Service.
Service completed.
Foxo is there.
Yes, sir.
Foxo.
Box 6.
Okay. Who is the conducting advocate?
Worship, he's on his way to board.
এই নি।
রিপোর্টটা আছে। ওই রিপোর্টটা আছে।
Service,
I am for the state, your lordship.
service report. Service report.
Yes.
Yes.
143, three fiber hardware and Sanjita, read section 4 and 17 of Works Act. The moment is rated about 19 lakhs and 16 Sanjita.
ইয়ে হলো আগে একটা করেছিল 3 নম্বরটা ডিসপাইট সার্ভিস নন অ্যাপিয়ার্স অন বিহাফ অফ দি ডিফ্যাক্টো কোম্পানি এখানে দিয়ে দিন ডিসপাইট সার্ভিস নন অ্যাপিয়ার্স অন ডিফ্যাক্টো কোম্পানি ইয়েস
Item 10, Lordship. I am for the state, Lordship. Lordship, this petitioner is a kingpin of this racket, Lordship, habitual offender, Lordship. To scope for granting anticipated several materials, money transaction.
হেমন্ত হালদার। রঞ্জিত সরকার। Charge sheet has been submitted.
Charge sheet, Lordship.
কালকে রেখে দিন।
No, they have certified generosity.
ঠিক আছে, নেক্সট, নট টুডে। How many matters will be passed over?
No, these matters were already heard. This is regarding that CID case of the joint video, my lord. A report
No.
was called for.
Yes, yes.
এটা কোনটা? Oh, sorry, sorry. No, it's not this matter. No. This case, my lord, the counter case was there. Counter case of the CD was called for, and I have got the CD of the counter case.
But prosecution was directed, item 12, yes, 12. But prosecution was directed to serve upon the victim. This is the compliance matter.
অভিষেক, মিস্টার অভিষেক সরকার। Yes.
Offense under section of 498A, 354A, 354, 354, 376, 500 given of the example. But petitioners are the father-in-law and father-in-law, but they are aged about not 53 years and 56 years. And father, 3 experts find defendant acting Shadda Khatun, Fajira Khatun and Sarkar. They have planted admissibility by the land petition judge. I have annexed the order, my lord. Moreover, my lord, petition number 1, father-in-law, 376 or 354 does not lie against the lord petition number 1. My lord,
Chavina.
there is a general allegation of my lord.
One is the mother-in-law and 2 is the father-in-law.
And my lord, allegation is that my lord, on 22nd of July 2025, the petition number was gave a
Right now.
time by that is the identification.
Yes.
This is the 164 statement of the victim, Lady Malad. This one admittedly against mother-in-law, general allegation, but against the father-in-law, serious allegation. Kindly see the next page. Relevant portion I have marked with the pencil, madam. Next page is the relevant portion. This is the 164 statement.
The dispute between not family dispute between the parties. Old age person for a.
Let me go through it.
This is the, sure.
What is the allegation against mother-in-law?
But in 164 statement, my lord, only online is there, all the persons torture upon him, torture upon her. That is the general nature. But against the petitioner number 2, that is father-in-law, there is specific allegation. But one neighbor statements of their page 161 statement, my lord, page 20, 10 and 13. 10, 13 and 20. Independent witnesses. Neighbor of the accused persons.
Ask. Yes. Your fault?
Is for the defect complaint lawyer.
Who is Mr. Abhishek Shortcut?
He's my senior. He is unable to appear today because he has undergone some major surgery recently.
What is your submission?
Lordship, we were only appointed yesterday, so we have not been served with a copy of the petition. Will it be possible to keep this matter on Monday and serve a copy on us within the time?
CDS.
The application against.
Otherwise, there is objection against this bill.
Sure. Let me advocate for.
Even the company is present there, and she personally engaged in the. Honestly, engaged with the legal aid, honestly, personally engaged.
Oh. What is your submission?
Against father-in-law, there is only an English. I see the complaint as well as one session. That is my petition number. But there is a delay of 3 days of the law. After filing,
Let me advocate for the petitioner. Submits that the complaint is a result of family disputes between the parties. There are no such specific allegations against these petitioners, who happens to be the parents-in-law. Other co-accused, who are relatives of the husband has been granted bail. Relatives of the husband has been granted anticipatory bail or bail. Anticipatory bail by the learned sessions judge. He seeks for anticipatory bail on behalf of the petitions. Opposing such prayer for anticipatory bail, then an advocate for the state submits that there are allegations against the parents-in-laws, especially the father-in-law. He seeks for dismissal of the advocate for the de facto complainant. Also opposes the prayer for anticipatory pain. Here use the case as materials and record. It is found from the statement of the victim, lady, recorded under section 164 CRPC, that there are specific allegations against the father-in-law, against petition number 2, father-in-law. For giving illicit proposals. And of attempt. Considering such materials, I am not inclined to extend the benefit of anticipatory bail to petition number 2. According the same is rejected. Para. As regards petition number 1, being the mother-in-law, it is found that the allegations are generic in nature. Considering above, 1 allowed to allowed in pardon.
Get from one.
দেখে নাও 1টা 1তে allowed 2 করে কেটে দিয়ে
আমি দিন কেসিস স্মার্ট আগে
আমাদের ওদের দিকে বলতে পারছিস না কত হ্যাঁ
সব লিখছটা
হচ্ছে না স্যার অসুবিধা হচ্ছে না
1 2
I'm asking for
13 my lord, this is that matter regarding the joint video.
Commission is arguing it court number 2.
All you have indicated that
My lord, we
documents?
have, yeah, my lord. We have brought all the documents, we have sorted from the CD, and this is the synopsis of the documents.
ঠিক আছে ask him to come.
Time short pass over. He will be hearing at this.
10 minutes, after 10 minutes.
Not 15, 20 minutes. Virtually, he is arguing in court number 2. That's all.
11:25.
Yes, Your
11?
Right.
11:15.
13 না এটা কতগুলো 1 2 3 4 5 6 ওটা কি পাস ওভার হয়ে গেল নেক্সট
But the allegation is under section 69 of BNP. And the de facto complainant is the sister of the alleged victim lady. From the FIR, it is clear there is 11, for last 11 months, there was no connection between the petitioner and the alleged victim lady. The gist of the allegation is that from the FIR itself, the the alleged victim girl used to stay with her husband for 6 years. Thereafter, her husband left her. Thereafter,
একটু আস্তে একটু আস্তে
ভীষণ দিয়ে আবার বলতে হবে
the gist of the allegation is that the victim girl used to stay with her husband for 6 years. Thereafter, the husband left the victim lady. Thereafter, she grown up a relationship with this petitioner. But after that, the petitioner left the victim girl. And the FIR lodged 11 months delay there is. And from the FIR itself, it is clear the lady was married and there was কিন্তু FI 11 মাস এইভাবে কেটে যায় কিন্তু কোনো সম্পর্ক বা যোগাযোগ করে না। But the actual fact of the case is that the de facto complainant and other family members gave proposal to the petitioner to marry this woman by suppressing the fact she is already married. On that ground, she refused the marriage proposal. FI is at page 8 Laksh.
What are the sections?
69 of BNX promised to marry.
Okay.
By deceitful means. My lord, this is the 164 statement of the victim. 183. And the victim lady is deaf and dumb. And my lord, her disability is percentage of disability is 80%. She is deaf and dumb lady, my lord.
Where is that?
That is page 22 is the disability certificate.
Hearing. He is the sole accused.
Yes, ma'am.
May I? Worship, from the FIR.
Learned advocate for the
6 years. Worship.
petitioner submits that the victim was previously married. Her husband left her.
Her husband left her, my lord.
Her husband left her. Thereafter, the victim developed love relationship with the petitioner. There are no such materials with regard to any forcible act. Medical
Medical is, my lord, at page
forcible act of the petitioner.
14. Page 14.
She is deaf and dumb.
Yes, my lord.
You know, she seeks for anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, an advocate for the state submits that the victim is a deaf and dumb lady, and the petitioner has entered into sexual relationship with the victim, taking advantage of the circumstances. She seeks for dismissal of the prayer for anticipatory bail. Peruse the case diary and the materials on record. 164.
Just page 40, the last page.
The victim is a deaf and dumb lady. The statement has been recorded through special educator interpreter. It is found that the victim, the petitioner entered into physical relationship with the victim. There are allegations of threatening the victim by posting of her illegal photographs, obscene photographs. Considering the aforesaid materials and the nature and gravity of the offense, rejected.
Great.
Hmm.
Great, my lord.
Even.
I'm for the state, your lordship.
15 before your lordship takes up this application. My lord, may I make an innocuous prayer, my lord? My lord, this matter I'm led by Mr. Ghosh. My lord, my lord, Mr. Ghosh could not come to the court due to some medical urgency. My lord, your lordship, my lord, I saw the cause this today. Your lordship will be taking up anticipatory bail applications till 3 p.m. My lord. But can this be taken up in the second half, my lord? As per your lordship's convenience.
Okay.
I'm good.
As per the court's direction, the
There was a report what?
payment report
Oh, you
has been collected by the IO and submitted there.
এটা সেকেন্ড হবে এটা
Okay.
কিন্তু ফাইভটা কিন্তু যেগুলো পাস ওভার আছে দিয়ে কোনগুলো রেডি আছে 5 onwards 5 onwards
Item number 5.
Well, as per the structure.
Remember 2 this is for before Yes, for default, they are on board. Yes.
302 मतलब 34 of the ignorant development. But allegation is that, but there is a long-standing or family dispute between the parties as per the FIR on 5th of July 2023 at about 5:30 p.m. The brother of the informant, namely Jaidul Haq, was returning home in front of the house of the accused person. At that time, the accused person restrained him and started assaulting him. Thereafter, the accused person stabbed him with a knife. Due to such assault, Jaidullah sustained bleeding injury and fell down on the ground. Subsequently, local people came to the spot. He was taken to the Dinata hospital. Thereafter, he was referred to the Kushbihar for better treatment. After receiving such information, the informant went to the hospital and subsequently he was expired. So that is the allegation.
He's the
But
brother
in
of the
this case-
petitioner. The person who has died is the brother of the petitioner.
Brother. But in this case, total 3 persons are required. But charge sheet has been submitted out of 3. But brother of the petitioner, but Noor Alam Haq, alias Noor Alam Mia, was granted anticipatory bail by the authority. Kindly see which case of my application.
Yes.
And my name is Noor Islam Mia. They are the full brothers. And another accused person, charge sheeted accused, Sholeman Mia, was arrested and granted bail by the learned court below. That is my instruction.
Any of the one.
Standing on the same footing, Noor Alam Haq was granted anticipatory bail. Kindly see, I am clearing the fact.
Yes.
Parity being full brother brother.
Because I know that that's it. That's if you go like
164, my lord. The allegation is distinct. Pointing towards this petitioner, my lord. He is the principal assailant.
Islam,
There is no question of parity.
Learned advocate for the petitioner submits that the FIR has been lodged in connection with family disputes which in which an assault took place resulting in death of the deceased. Where is the PM report?
54, my lord.
54. The co-accused, sorry, the deceased is the brother of the petitioner. Other brother, namely Noor Alam Haq alias Noor Alam Mia, he is also the brother.
Yes.
Has been granted anticipatory bail by this court. The petitioner stands on the same footing. He seeks for anticipatory bail behalf of the in favor of the petitioner. $50 50 is the PM report?
54.
Opposing such prayer for bail, and an advocate for the state submits that this petitioner has been named by the witnesses in the 164
And 161 also.
and 161 CRPC to be the principal assailant He seeks for dismissal of him. Here is the case and materials on record on the statement of the witnesses recorded under section 164 as well as 161. There are specific allegations against this petitioner of assaulting the victim on the date of incident by a sharp cutting weapon. উপরে ওনার সাবমিশন করে চার্জশিট সাবমিটেড। As per the PM report, the death was due to effects of injuries noted therein, which is anti-mortem in nature, considering the type of materials and nature reject.
Probably.
পরপর ডেকে যান। পরে কি আছে?
Just file this, some official staff had been to the office, whether they have sent the mail or not.
First of all, Lord, kindly come to page 9, my lord.
Affidavit of service.
Yes, sir. Victim indicated and present.
Where is the affidavit of service? State is died. Service report by the state.
Yes, already we have registered your file.
Oh, yes. So, okay. Who is for the de facto? Nobody is appearing anyway. What is this case?
Lord, first of all, kindly come to page 9, my lord. Page 9. My lord, this is the, my lord, the complaint. My lord, which is, my lord, the retaliation of my lord complaint. Lord, page 9. Lord, the victims, Lord, the elder brother.
No, who are the petitioners here? The complainant is a petitioner.
Lord, I am coming to that aspect, my lord. So kindly consider this, this one first, my lord. My lord, in this FIR that was lodged by one, my lord, Nirmal Bormul. He is, my lord, the elder brother of the victim. Now, the gist of this FIR is that, my lord, while, my lord, the elder brother of this complainant was, my lord, coming towards his home, he was, my lord, obstructed by the accused persons and, my lord, manhandled and, my lord, assaulted. Lord, if your lordship kindly come to the next page, that is page 10. I have, my lord, annexed few, my lord, injury report of the victim. Page 10 onwards.
Page 10 is internship.
My lord, page 11, page 12.
No, this is
12, 13.
internship program.
Lordship. My lord, these are the injury report, but he was.
Page 10 is not an injury report. He was
No,
attending an
12 and 13.
Yes.
12, 13. My lord, the victim was taken to nearby, my lord, the subdivisional hospital. He was treated, and these are the medical report.
So who is Manik Chandra Burman?
Yes, my lord, I am coming to that. My lord, here, my lord, the accused persons are one Maluti Bormun, Amul Bormun, and Amit Bormun. 3 accused persons. My lord, kindly come to page 9. Page 9.
Amit Burman. Yes.
My lord, in earlier complaint, my lord, in which, my lord, the complainant, my lord, narrated the incident with regard to which happened, my lord, on 26th of June 2025. The narration was that, my lord, the allegation was that the elder brother was coming, he was obstructed by the accused person, he was manhandled, and, my lord, assaulted.
My lord, out of retaliation, my lord, revenge, this complaint has been lost, against which, my lord, this particular petitioners is, my lord, praying anticipatory bail. My lord, here the complainant is one Maloti Bormo, who was the, my lord, the principal accused in that FIR. Now, my lord, the victim in my FIR, my lord, was, my lord, the father of the petitioner number 1. He is the father of the petitioner number 1.
Who is the father?
Father is, my lord, my
প্রত্যেকের কাছে সাবস্ক্রিপশন
মানে আমাদের নিজেদের কাছে
Seriously, Jan, man. What the report? You are for the petitioner?
Lordship. Lordship, this is the, I'm being led by Mr. Majumdar, he's online. This is the supplementary affidavit.
Give a copy to the complainant and the state.
I have given Lordship.
What is this case?
Lordship, may I place the records in a nutshell? Lordship, the accused petitioner and the de facto complainant happens to be cousin brothers. Cousin brother. Maternal brother.
Accused and the de facto complainant.
Yes, Lordship. Now, what happens, Lordship? Kindly notes down the dates. On 5/5/2025, this petitioner, that is Raja Mondol, he lodges one complaint against 3 persons before the police station, and it has been general diary has been registered. Regarding then subsequently,
3 persons, including the complainant.
including the complainant. Now, what happens, Lordship? On 10/6/25, the complainant issued a check in the name of the accused person. What is Lordship? Okay. The check was placed for encashment and it was dishonored. And the reason memo dated 11/6/25 was given by the bank, honoring the check on the ground of insufficient fund.
Dishonor.
On 11/6/2025. On the same day, a legal notice, it was communicated to the accused that the check has been dishonored. Either you make the payment or I have to proceed according to law. And on the very day,
This check was issued by the complainant.
by the complainant against me, in favor of me, that is the accused person of this case.
Legal notice was issued.
No, Lordship, I am coming to that. On 11/6/25, when the bank returned the check, honoring the same on the ground of insufficient fund, the accused person of this case called his brother that your check has been dishonored, so you make the payment or I have to proceed according to law. On the it was returned by the bank on 11/6/25. Now this date is very vital. Why, Lordship? On that day, after receiving the telephone conversation, the complaint was lodged. The present complaint before we on 11/6/2025.
Yes.
And we are not aware of that fact. We issued the legal notice on 16/6/2025. Lordship was within 1 month. We have to do it. We have issued the notice. Now, Lordship. Now, this case alleging that certain amounts were given. Admittedly, Lordship, what happened? There was a gym. There is a gym.
Yes.
Now, the complaint says that he has invested some money to the business of the gym. For complaint of this case. Obviously, when the gym will start running, the profit will be obtained. Then his share of money will be given. Now he wants his money back because we have claimed the money. So it is a dispute. Who the investment is not disputed. The account money transfer is not disputed. So what share who gets is a civil dispute. That is the reason when we.
But then this dishonor of the check
That's another
has nothing to do with the loan that was being advanced to the accused.
By the complaint, by the accused to the complaint. So in return, he gave the check. So there is a transaction, admittedly. Now, who gets what? That's a civil dispute. Now, we don't disagree that the accused person, that the complainant invested in the business of gym. We don't disagree. But 406, 420. Our intention that Lordship knows that Delhi raised a judgment also in Supreme Court. That whether in one hand criminal breach of trust, at the same time cheating. Because in a criminal breach of trust there has to be an entrustment. And in cheating there is no entrustment. So both cannot go hand in hand together. Simultaneously. Now, as kindly says Lordship, the order passed by the coordinate bench giving us that protection. Now the thing was, now we are in a juncture that whether the notice issued to us 41, whether we have complied or not. That's the question before my lord. Now, what my brother has stated earlier that during investigation the police overacted and without finding me in my house took my motorcycle. A writ petition was filed and he was that there's another juncture. The police came to my house, did not find me, took my motorcycle, which is no way connected to this thing. And noted we have filed the supplementary order sheet and it is page 23, the order of the writ petition. And kindly note down the date of the said order. The supplementary will just now I have handed over. Page 23, my lord.
Yes.
This is Batu Chaudhary's order. Kindly see the date 19/8/2025. Now, this is the said order by which the police officer was literally threatened in the court and he was told to return the article. Now, this made the police officer annoyed, very much annoyed. And what my brother was submitting that we went there, police says no, he did not come. Now, kindly sees once, for my satisfaction of see, page 4 of the supplementary we have handed over. Page 4, annexure P6.
Yes.
Lordship, this is the 41 notice issued to the accused person, dated 13/9/2025. The order was passed on in writ petition 19/8/20, so 1 month prior to that. Now, getting the same, kindly transfer the page to page 5. I went there. I was not even entertained by the police officer. You went to court, go to court. I wrote a letter to the IC. Now, the question is whether this letter was received or not. The IC did not receive the letter. Kindly transfer. I have sent it through. Kindly see the date, Lordship. 18/9/2025. Now, Lordship, the track report. Consignment, page 8. Delivered on 19/9/2025 at 14:24 hours.
This is 18. Oh.
So, Lordship, at least at this juncture, I am being able to demonstrate that my bona fideness. I went there. They did not receive the. IC also did not receive. I had to send it through post. And Lordship knows the track report also says it's delivered. Now, if this action was illegal or false, the police could have given a reply that you did not turn up. Why are you giving this excuse? So this is the trust point at this juncture.
Okay.
So if Lordship directs me a particular time and date, I may go to the police, comply the same. If not, then I'll come back again to court. That's my submission, I think.
Finished. Lordship, first I will invite your Lordships. The conduct of the petitioner. Lordships, regarding the transactions that the defendant has already paid 70 lakhs, they can't deny it as because entire amount transferred by the account pay chief, and that has been seized by the IOD Lordship. entire account. And what happened, your lordships? This petitioner took money from his mother also, and after together they have paid amount. In total, 130 and 70 lakhs by cash, by taking loan from the seeker sponsor and several. And that accused petitioner assured that they will start a business gym and they will start a business and he will get some portions. But what happened? The conduct of the petitioner from the very inception to cheat that persons. Inception is clear, your lordship, from the very inception, he intended to cheat. That's why he took money from the defector complainant and thereafter he started running the business. But till date is not bothered to participation in the gym and did not return back the yes, you are not my partner, I will return back. There is no such documents. Lordship, he said this is a civil debit. What is civil debit is totally different. It's a cheating, His Lordships. It's a clear cheating, Your Lordship. The inception of the very inception, pilot knows better than us, Your Lordship, being an experienced judge, Your Lordship. The cheating indicates here, Your Lordship. And moreover, Your Lordships, the previous, when the appeared before court and when the landed court thinks here there is a transaction, your predecessor, you already give a direction to you meet the IO and provide the documents and the health or prosecution case. But what happened, Your Lordships? As and when they got the one protective order, Rakha Kavach, Your Lordship, not to take any coercive measure, now they have started playing with the IO. They never had been to the police and they sent the poster that you refused to appear by, that's why I sent it. This is the playing, Your Lordships. So heroic playing is going on, Your Lordship. Lordship, I will file today. I will file one report submitted by the IO. My lord, I have already handed over to. Can we see, Your Lordship? The entire case.
Accused. When? No date.
During investigation, Your Lordships.
Which date, sir? Where is the copy of that notice?
Yes, Lordship, I said that as well. Unfortunately, father of the IO, that's why.
We are concerned with the investigation and the way it has been taken up after 8 September 2025. By the order dated 8 September 2025, court directed the petitioner, you join the investigation. He says, I went on 18 September, but since the IO did not entertain me, I wrote a letter. He did not receive it. I have sent it through raised post. He gives the IO gives a report wherein he says that he issued notice under 35(3) twice. This does not have the date. Was it prior to 8 September or it after 8 September? Date is missing. If it is in the case diary, you kindly place that. You find out? After that, what happened? He says that he appeared. You say that he is not appearing. What is this going on? If he is willing to appear, let him appear. There is a direction, let him appear. Where is the IO?
That's why he could appear and earlier occasion indicated by the office JP.
No. You cannot put any petitioner in a garb of illegality when he is willing to comply the order of the court. By way of supplementary affidavit, he says that he went to the PS. The IO did not entertain him. You place the notice dates that after 8 September you have issued a notice, he did not appear. But this cannot go on like this. He has been given a liberty, let him join the investigation. If he flouts that order, then we will see what happens.
He said, one day he will be able to come before your person.
Okay.
You assist the paper.
The report filed by the state is taken on record. Supplementary affidavit filed by the petitioner is also taken on record, copy served. By order dated 8 September 2025, the petitioner was directed to join investigation. Mr. Saurabh Ganguly, learned advocate for the petitioner, submits that his client, pursuant to the order passed by this court, had been to the police station to join investigation. However, he was not entertained. Entertained. And he was constrained to submit a letter before the inspector in charge. Which police station is it? Kujbihar Kotwali. Learned advocate, Mr. Obhijit Sarkar, learned advocate for the state, submits that the petitioner has not complied the order of this court. In view of the submissions made on behalf of the petitioner, a further report be furnished with detailed dates on which the notice under section 35(3) of BNSS was issued to the petitioner/accused persons. List this matter on Monday.
That is on 17/9/2025 at 12 p.m. And on 18/9/25 as per order we went to the PS. So on the CCTV recording of the police station dated 79 and 89 may be preserved, because they can take the blame. It will suffice that whether we have going because if we are protected, why will not complain? Because we are having in terms of
My lord, what is the direction to be trial? If someone, anytime he had been to the, in front of the police station's camera.
No, Mr. Sarkar, this is not done. If he suppose if a time is not given, for your sake of argument, I consider that time is not given. Sir, please. He went to the police station. The authority could have said that no, not today. You come tomorrow in such and such time. Ask. Get a report from the IO. No. Next.
No, 7%.
None. No personal appeal. Let him get a report.
But I am appealing for this statement.
Lordship, 7 I beg to appear for the petitioner. My lord, I believe there is some technical glitches. I'm unable to see the court.
Okay. Mr. Banerjee, we do it, pass it over. There is some technical glitch. Huh? So after some time, I will call this item after 12:30.
12:30. Grateful, my lord.
Yes.
I think
8.
I'm for the state, my lord.
নেই
শুভাশিস
এই তো ছিল
আট নম্বর ম্যাটার
This Foxo.
Foxo.
Is me, my lord, I am the paternal aunt of the principal accused number 1.
Paternal aunt. PC, ne?
Yes, PC. My lord, both the complaining family as well as my lord, the accused family are residing on the, my lord, the same village. The accused are same.
What is the allegation against you?
My lord, this is the 164 statement. Yes,
Service
done one. This is the 164 statement.
My lord,
Specific allegations of that.
My lord, the principal accused, my lord, the entire allegation is based against my lord, the principal accused. That is my lord, one time. Bill Hall, the boy. Lord, I have to ascertain, my lord, whether he has been granted bail or not. Landscape is animal, my lord, I am doing instruction.
তারপর রুবিন
So if your lordship kindly put the matter on Monday, my lord.
এটা কি রুবিনা no no dispose of this
Against her, my lord, there is no specific allegation. Save and except, my lord, a concocted story has been projected that, my lord, this particular lady, my lord, this petitioner has
এতে করবেন 7টা 12:30
11 না
করবে
Lord, I am for the petitioner. Lord, this matter was adjourned on the last occasion for the want of case diary of my case. Lord, there were two cases, Lord, two cases and counter cases. Lord,
both the case juries are here, man.
Lord, just in nutshell, I'll be reiterating the facts. Lord,
this is a you submitted that case and counter case in the earlier case, that is case against this petitioner.
yes.
Huh?
Both
the parties sustain injury.
Lord, I have placed a supplementary affidavit, Lord. Now the case diary is also here. Lord can ascertain, Lord, whether my injuries were previous or not. And Lord, investigation has completed, Lord. So there is no immediate requirement of custodial detention, Lord. I'll change the fact, but
What
my
is it?
specific submission was, Lord, there is no mens rea, no premeditated act of causing injuries to me. At the heat of the moment, Lord.
No.
My lord, there are 4 petitioners. Out of that, petition number 1 and 3, they were injured. As per the case diary of Sitalkuchi, page number 60, I have folded the pages. Regarding the petition number 1, his injury report is there, but petition number 3, there is no injury report, but a bed ticket is there. I have folded first the But regarding the petition number 2 and 5, there are no injury reports or any kind of medical documents.
But these medical documents are annexed in my affidavit.
He was admitted to the hospital.
My lord,
So where is the admission, discharge certificate?
that we don't have, my lord. This is the discharge, this is the injury report of petitioner number 1, Ukil Burman.
Okay.
And Chandrajit Burman,
You have got the discharge?
Yes, but Chandrajit Verma was referred to private medical blood. Kindly come to page number 32 of my application.
The head injury.
Page 32 is the referral card blood from the government of order. Thereafter, page 67 is the further medical documents not where you are referred to. Various reasons. But my supplementary affidavit also, but some photographs are annexed there. If Lord wants to peruse it, Lord.
photographs are there in the CD.
And the case diary of this case? This is 60.
This is the injury report of case. This is 58, my lord. Shitalkuchi 58. That one is 60. Five injury reports are there.
Anybody died?
No, no, no.
আসামিদের বেড়ে গেছে
Yes.
Statements?
Statement 1 eyewitness is page number 24, my lord.
The statement of the injured?
Page number. That's for page number 8. 8, 19, 20, 21.
6 are injured.
Five.
Find out the statement of the injured. They are none of them are injured. Hiroj, Sopon.
They have obtained anticipatory bail from the landed court. In my case, they have obtained anticipatory.
But page number 71, statement of the victim person, namely Shankanath Korma. 71, my lord. Then page number.
Kokila has been granted bail.
Yes, the lady members are gone.
Learned advocate for the petitioners submit that this is a case and counter case. In the alleged incident, the members of both the sides sustained injuries. The petitioner number 3, Chandrajit Bormon, sustained head injuries and had to be hospitalized for better treatment. The co-accused have been granted bail by the sessions judge. Anticipatory bail?
Yes.
Anticipatory bail.
Few anticipatory, few blood regular.
Granted anticipatory as well as bail. Anticipatory bail as well as a regular bail by the sessions judge. He seeks for anticipatory bail of the in favor of the petitioners. We're going to be picking Ukil. Opposing such prayer for bail, learned advocate for the state submits that in the said incident, 6 persons sustained grievous injuries. And there are serious allegations against the petitioners of attacking the victims in a group. He seeks for dismissal of the anticipatory bail. Here is the case diary and the materials on record. It is found from the injury reports that the victims sustained cut injuries on the cut injuries as well as lacerated cut injury in the occipital region, forearm, thigh and other parts of the body. And all the injuries are grievous in nature. The injured persons have been referred for admission to higher medical center. The statement of the victims shows the involvement of these petitioners in assaulting the victims. Considering the nature of the injuries sustained by the victims and the offense, the magnitude of the offense, which resulted in injury to the 6 persons. Sorry. Rejected.
For the number 3, who himself was in hospital for more than 20.
There are allegations.
Lordship, item number 7, can it be taken now?
Yes, 12:30 will take. Seven.
My lord, I beg to appear for the petitioner, lordship.
For the petitioner?
My junior is there, his Chakraborty is there.
Yes.
May I place the facts?
Yes. State. You are for this? Okay, yes.
Yes. My lord, this is a anticipatory bill arising out of an FIR, which is in connection, is a counterblast of the contractual dispute, lordship. The allegation is, being a promoter, I have not constructed the roof of the de facto complainant, the person who has complained. My lord, the agreement is there from page number 10 onwards, lordship. The picture shows from 17 the work which has been done by me. And lordship, there are certain complaints which has been initiated upon my instance. There are certain difficulties to continue the business in that area. Now, lordship, what happened? The de facto complainant, lordship, they have stopped the payment of EMI from their end. Now, lordship, their check has been dishonored. The check which they have paid for the EMI, that the same has been dishonored. Lordship, kindly take page number 33. This is the notice, page number 33 of my application. This is the notice under section 138 that lordship I have forwarded to the de facto complainant that your check has been dishonored. Lordship, the same notice was reached to the de facto complainant on 27th July. Lordship, as a counterblast, they have initiated one complaint against me on 8/8/2025. First, I have sent them a notice as their check has been dishonored. And after a couple of weeks, lordship, they have turned up with, lordship, this complaint, lordship. Their complaint shows, kindly take the page number 37. Their complaint shows, their allegation is that the roof has not yet been constructed as I am promoter, lordship. Now, lordship, that is simply a contractual dispute, lordship. Now, lordship, the certain difficulty is, my lord, I must candid before this court. There was an order passed by the earlier bench not to take any coercive action. As lordship, a notice has been served upon me for the purpose of investigation, lordship. Through one counsel, they have communicated the same to the IO, to the concerned IO. Now, lordship, the IO is creating difficulties to appear before the IO, and for that reason, one writ petition we have filed before the bench, and that writ petition was disposed of, giving liberty to agitate the same as the application is pending before this court. This is number one. Number two, lordship, as my complaints was there, that has not been registered. Another writ petition we have filed, and that has been disposed of by Honorable Justice Hiranmaya Bhattacharya, and upon that instance, I believe the police is investigated the same. Now, lordship, one thing is very crystal clear, lordship, as a counterblast that has been done. There's a Supreme Court judgment is also that, my lord, is well-known award of that, lordship, that the civil score cannot be done in instance of FIR, lordship. But this is a pure civil dispute, and we are eager to run the business. We are ready to create. We are ready to go for to that area and to construct the roof also, my lord.
Okay, steps have been taken. So you say that steps have been taken for construction of the roof?
I am eager to. I am eager to, lordship. I am eager to.
What stops you from doing that?
Lordship, there are the difficulties, is Lordship, the case and the counter case is is there, and no arbitration clause is also there that the parties can sit together and something can be done on that part. Because I have communicated to my client also.
Okay.
Because this is not a fit case for FIR, as it is not an quashing case, but still.
My lord, first of all, my lord, prosecution was directed to produce the status report. This is the status report, my lord, showing four number of previous antecedents. Sections are more or less same. First of all, my lord. Secondly, 35(3) notice was served upon the petitioner, that was received by the petitioner, but did not comply the. This is the notice, and next page is the, my lord, kindly see the notice served upon the petitioner, but he did not turn up before the investigation agency and never joined the investigation, my lord.
Why, Mr. Banerjee, you're not going?
Lordship, the notice is.
Next page is the, my lord.
Lordship,
report. My lord, the.
Lordship, page number 32 is the notice. That is there, Lordship. But what if, because I have agitated the same before Justice Bhattacharya, Honorable Justice Hiranmay Bhattacharya's bench also. Lordship, the difficulty is the IOB is claiming the amount, the money. I have also talked with the council who is now appearing on behalf of the state.
My lord.
Yes. Next.
My lord, this is the 35(3) notice, and next page, my lord, the 172 part, my lord, only next page, just next page. There is written as he has not turned up before the investigation agency.
I am eager to. Rishita, kindly hand over the copies of the writ petition. Lordship, there are 3 orders of the writ petition. I am approaching this judiciary. I am not escaping from anywhere to anywhere.
The important 161 statements are there in the case diary, my lord. Kindly see page 14, 15 and 16.
PRM.
14, 15 and 16 are the 161 statements of supervisor and, my lord, marketing manager and the engineer. 14 onwards.
The name of the complainant, Jivande.
My lord, the complainant.
Yes, my lord, Jivande.
Yes,
To Jivande, we have sent the notice
Yes,
under one section 138. Jivande.
These are the money receipts.
They have paid some amount to us. They
Agreement
have
also
paid
paid,
certain amount to us. Agreement was there, and they have stopped the EMI. And the check has been dishonored. We have sent them notice.
Investigation still in progress, your lordship.
Lordship, we are eager to go to the police station, Lordship. There's nothing to hide.
Lord Advocate for the petitioner, state files status report which is taken on record. Lord Advocate for the petitioner submits that the complainant had entered into an agreement with the petitioner, who is a developer of a building. This agreement for sale, for a flat.
No, for a dwelling
For
house.
construction.
For dwelling house.
Construction of a dwelling house. Post dated checks were issued by the complainant in favor of the petitioner. the the complainant alleges that the work of the rooftop has not been constructed as yet by the petitioners. Both are developers.
His lordship, one is
Uh,
father and son.
Petitioners. The petitioner has placed the checks issued by the complainant to his banker in his bank, which has been returned with endorsement stop payment. Correct?
Yes, my lord. Stop payment.
Stop payment. Notice under the NI Act has also been issued to the complainant. The dispute is entirely civil in nature, which has been given a criminal picture. The petitioners are willing to cooperate with the investigation. However, due to high-handedness of the investigating agency, they could not join the investigation. Being constrained by such action of the investigating agency, the petitioner approached this honorable court in a writ petition being WPA 1946 of 2025, seeking for a direction to join investigation.
Lordship, this is the 1946 is to register FIR, Lordship. This is 2195.
2195 or 2025.
1946 is for the FIR.
2025. He seeks for grant of anticipatory bail in favor of the petitioners. Learned advocate for the state opposes such prayer and submits that the petitioners are involved in similar fraudulent activities and several cases have been filed against them. The petitioners have not cooperated with the investigation. He seeks for dismissal of the application for anticipatory bail. Para. Here is the case diary and
11111 of BNS also added.
what is that?
This is a wrong section. This is that new added section. This IO it creates trouble.
And
111.
section People 1 of BNS has also been added.
This is an organized crime, my lord.
By the order of the court.
Yes, it is.
Here is the case diary materials on record. There cannot be any quarrel that for development of a house of the complainant, an agreement was entered by and between the parties. There have been some financial transactions. The allegations as made out is a contractual one. Considering the same, I am inclined to extend the benefit of anticipatory bail in favor of the petitioners. The condition there is meet the investigating officer once in a fortnight until further orders, 438 subclause 2, and the petitioners will join investigation and cooperate in the investigation. Hello.
Mr. Grateful, Lordship.
Yes.
Grateful.
Malad, before Malad go to the next matter, in earlier matter number 11, item number 11, Malad, though it was rejected, but there was a earlier order for not to take any coercive action, Malad. So, in online order should be added, Malad. That order will have
the interim order stands vacant.
Fine. Previous one, item number
By
11.
11. 11 to add good in interim order if any stands vacated.
Yes. Otherwise, there will be a confusion.
Thank you.
Item 13.
13.
The incident is of 2012-2013. The first charge sheet in the instant case not was filed after 10 years of 2020. I superannuated in 2015.
No,
That's
the
not more than 10
offense
years.
is of 13-14.
No. The offenses are 406, 409, 420.
No, it's of 2013 and 14.
12-13.
And you have been charge sheeted in?
I have been charged in 2025. That too, I came to know from the order of the court, 3rd of April 2020. Now, this is regarding a Manrega scheme where certain anomalies go unnoticed. Now, as per my understanding, if there was any anomaly, it has to be taken care of by way of documentary evidences. There has to be photographs of the site that has to be taken. There has to be other documentary transactions. There has to be eyewitnesses to that effect. Now, those things are already complete. Even otherwise, I was a joint video. If I can have also for a moment on the scheme of the act, I will be referring to section 7, 13, 14, and 15. I will begin with section 7 first. Under the scheme, there is a program officer. 7, subsection 4 says that the unemployment allowance payable to the household of an applicant jointly shall be sanctioned and disbursed by the program officer or such local authority, including the panchayat at the district, intermediate or village level, as the state government may by notification authorizing this behind. Then comes note
13.
Section 13. Who is the principal authority for planning and implementation of the schemes? It is always not the district program coordinator. I will come to that. Section 13 says the panchayat at district, intermediate, and village levels shall be the principal authorities of planning and implementation of the scheme made under this act. And then 4 says the district program coordinators shall assist the panchayat at the district level in discharge of its function under this act and any schemes made under. Then section 14 says district program coordinator is the chief executive officer of the district panchayat or the collector of the district or any other district level officer of appropriate rank. And a district program officer can never be, at section 15 it is there, can never be somebody who is below the rank of a BDO. I was never a BDO, I was a joint BDO. And what I did say, after 10 years of my superannuation, there is no chance of tampering with any evidence or influencing any witness because I do not have that authority now. I have already superannuated. Apart from another than that, if I can have also for a moment on the bail application.
Retired on which year?
2015. It's been 10 years now. If I can have also for a moment on page 5 of my page 4 and 5 of my bail application. There are total 14 accused persons. Everyone is on bail. And accused number 2, 3, 4, and 11, they have been granted anticipatory bail.
4.
Page 4 of the bail application. I have prepared a table.
Who have been granted anticipatory bail?
Accused number 2, 3, 4, and 11.
2.
11 by the trial court and 2, 3, 4 by the high court.
2, 3, 4. What is the position of 2? 2. What is the position of 2?
They are participating in the trial.
Not in the as a authority. What is their rank?
This 2, 3, 4. They were all working with they were officers of the post office. They are the one who has disbursed the amount. It is the allegation that they are the one who has disbursed the amount to the wrong person.
But then you and these people does not stand on the same footing.
No, I was with the video office.
Yes. So you are a signatory.
They are the final disbursing authority from whose hand the amount has been disbursed. The only allegation against me is that I have countersigned the checks.
But then these 3 persons were not in a position to scrutinize whether this amount should be disbursed or not.
Take accounts from which the amount has been disbursed.
But 2, 3, and 4 are post office.
They are all post office officers who have disbursed the amount to fake person on fake accounts. That is what the allegation was.
Okay.
Now, as per the previous order, there was a protection that was granted to me, and there was also a caveat there. If I can have also for a moment on paragraph 5 of the previous order dated 12th of September 2025. It says, in the meanwhile, let the petitioner join the investigation as written directed by the investigating officer and the report to the investigating officer till the conclusion of the investigation qua him. However, no course action shall be taken against the petitioner without serving 2 weeks notice. It's been 70 days. Even if they wanted to serve me 2 weeks notice, they could have served 5 notices by now. That means my requirement is not there. During inquiry or during investigation or during subsistence of this interim order.
No notice issued.
No notices have been issued against me. I am cooperating, my attendance is there, I have brought my attendance, on every week, I am going to the IO and my attendance has been reported there without fail. Under such circumstances, not looking into the fact that this incident is old and I have also been informed there are more than 100 witnesses. So this trial, when the trial is going to get concluded, that is also something that needs to be looked into.
Within your lifetime or not?
During my lifetime or not, that is also
Yes.
something that.
Well, certain documents were asked for. These are the documents. The specimen signature of this petitioners on the check, master roll, and measurement book, and the report of the from the experts, my lord, and these were asked for my lord, from my lord, and this has been produced by the IO.
You're facing a departmental proceedings?
No. But confidential report I have submitted excellent track record. Till the date of my superannuation. A++. In fact, I was the first inquiry officer of this case. Not think there is something that needs to be collected any further in this case. Not have you cooperated with the investigations.
How the accounts under the Manrega is created? Suppose a job card holder is there. Who is the authority to?
In fact, should hold on the act. I just want to look at it. So here is a central council now, but we will not be looking into that now. It will come to the responsibilities of the Gram Panchayat and the program officer. And then there is a social audit also that is done. I am sure they have done the audit, and from there the anomalies should have came. 16 is the responsibility of the Gram Panchayat. How the project is started, how the funds are collected, how they get it. It's a responsibility of Gram Panchayat. The Gram Panchayat shall be responsible for identification of the project in the Gram Panchayat area to be taken up under a scheme as per recommendation of the Gram Sabha and the Ward Sabha, and for executing and supervising such works. Then I will come to the funding pattern. Paragraph 22. Section 22. I'm so sorry. Section 22. The fund is met by the central government, but 23 is important. the district program coordinator and all implementing agencies in the district shall be responsible for the proper utilization of the fund. The district program coordinator is the VDO.
Oh.
It cannot be less than the VDO. That will also find that section 50. Any person who is not below the rank of the block development officer has to be the program officer. At best, I was a co-signatory.
Yes, Mr. He is the only, that is the allegation that he is the co-signatory.
My lord, because those checks are there, my lord, everything is before my lord.
Ask. Learned advocate for the petitioner submits that the case was initiated way back in the year 2013-14. The petitioner, on superannuation, retired from service as a joint BDO, Block Development Officer, in the year 2015. The only allegation, sorry, Kiridam. The name of the petitioners surfaced after filing of supplementary charge sheet in the year 2025. Mr. Misra, just follow the
March 2025.
25. Needless to mention that at the instance of this petitioner, inquiry was carried on at the foremost.
And I was the first inquiry officer.
And he was the first inquiry officer. There are 14 accused, out of whom 3 of the co-accused, who are officers of Postal Authority, has been granted anticipatory bail by this Honorable Court. Referring to section 7(4) of the Mahatma Gandhi National Rural Employment Guarantee Act, within bracket MGNREG Act of, in short, hereinafter referred to M1 of 2020 of 2005, he submits that the program officer is the person who is responsible for sanction and disbursement of the fund. The present petitioner, being the joint block development officer, was not the program officer. No. He further refers to section 13 of the Manrega Act and submits that the panchayat at the district, intermediate and village levels are the planning and implementing authority of the schemes of the government. 14, which clause you are referring to? 14?
In 14, I refer to clause 2.
Further, as per section 14, the district program coordinator is responsible for implementation of the scheme in the district in accordance with the provisions of the Act. He further submits that section 16 of the Act makes the Gram Panchayat responsible for identification of the projects in the Gram Panchayat area under a scheme, and the Act also provides for a social audit of work by Gram Sabha in terms of section 17. For the sake of transparency and accountability, Section 23 of the Act provides that the district program coordinator and all implementing agencies in the district shall be responsible for the purpose of utilization and management of the funds placed at their disposal for the purpose of implementing this scheme. The petitioner, being a joint block development officer, is
have been the program officer as per section 15.
15.
What 15? It is who is not below the rank of PD.
Being a joint block development officer cannot be a program officer since he is below the rank of block development officer. Bracket is section 15. Therefore, the allegations as leveled against the petitioner boils down to the fact that he is only a joint signatory to the check those were issued. Neither the petitioner has any connivance of creating fake bank accounts for transfer of those accounts, nor he is responsible for any of the actions under the Act. The petitioner has all along cooperated with investigation in terms of the previous order of this court and is willing to cooperate with investigation in future if so requires. He seeks for anticipatory bail the petitioner. আচ্ছা রিপোর্টটা ফাইল করে সেটা দিয়ে দিন না রিপোর্ট ফাইল বাই দি না এটা তো সিনপসিস আমাকে করে দিয়েছিল দরকার রিপোর্টে দরকার নেই ছেড়ে দিন মিস্টার নিলয় চক্রবর্তী লনের অ্যাডিশনাল পাবলিক prosecutor submits that this petitioner is a joint signatory to the checks that were disbursed to fake persons and there is misappropriation of public funds. The involvement of this petitioner transpired in the subsequent stage of investigation. He seeks for dismissal. On such score, he seeks for dismissal of the prayer for anticipatory bail of the petitioner. Admittedly, the petitioner is a joint signatory of the checks those were disbursed, allegedly to the fake accounts. As per section 15, a program officer of the Manrega Act, section 15. A program officer should be a person not below the rank of block development officer. The section 23 provides that district program coordinator and all implementing agencies in the district shall be responsible for the purpose of proper utilization and management of funds. Considering the aforesaid and also bearing in mind that the petitioner has all along cooperated with the investigation, I am inclined to extend the benefit of anticipatory bail in favor of the petitioner. Accordingly, he will meet the investigating officer once in a fortnight until further orders and shall also join investigation and cooperate in investigation. Can I, Mr. Chakraborty, keep it in record or you? নেক্সট কোনটা পাস ওভার আছে বলুন, দেখে যান তাহলে, আরেকটা দেখে নিন।
Item 16. Uncontested lordship.
Call for the report that whether WP issued or not, WP issued lordship on 16 June 2022. Present petitioner. This is the report, lordship. এটা একটু দিন না।
None appears on behalf of the petitioner. State files a report which is taken on record. Who is for the petitioner?
শুভাশিস মিশ্রা।
এফসি আসেনি, গতবারও আসেনি। অ্যাডভোকেট ফর দি স্টেট, আচ্ছা স্টেট ফাইলস রিপোর্ট ওপরে করে দিই। অ্যাডভোকেট স্টেট সাবমিটস দ্যাট already process of proclamation and attachment has been issued against the petitioner. It is found that on the previous date, that is on 18th November 2025, the petitioner failed to appear. None appears on behalf of the petitioner on repeated call. In view of the above, the application being CRM A 737 of 2025 stands dismissed for non-present. WPA has been issued.
Well, WPA has been barred from my anticipatory bail.
What is the fact?
Court has clarified.
What is the fact?
Lord, it is suo motu FIR, my lord, lost by the police. My lord, with regard to my lord, an allegation of my lord that a few amount of my lord illicit liquor has been stored, my lord, in the house of one Radha Gobindo Bormon. Now, my lord, Radha Gobindo Bormon, my lord, that person has been granted anticipatory bail by the learned trial court. Now, my lord, there are 25%, my lord, they have been arraigned in the, my lord, the suo motu complaint. And my lord, on the contrary, my lord, I have not been named, my lord, out of that 25%. Charge sheet has already been filed. Several, my lord, other accused person have been granted bail. And my lord, even my lord, that person, my lord, in whose house, my lord, the illicit liquor was allegedly, my lord, stored. So far, my lord, the allegation is concerned.
Bharat Sarkar,
This particular petitioner, Bharat Sarkar, who has not been named in the FIR. So out of co-accused statement, his name has been entangled in the, my lord, charge sheet. My lord, all the bail orders, my lord, anticipatory bail order, I have annexed, my lord, kindly peruse. And more particularly, my lord, that Radha Gobindo Bormon. My lord, page 11 is Radha Gobindo Sarkar's bail order.
But those are way back in 2020, 2019.
2019, my lord, and thereafter several others have been granted bail.
Where is that?
For the right from page 9.
Page 9, that is what I'm saying. 2020, 2019.
Page 10, page 11, page 12. Page 13 also. In page 13, my lord, in total, 21%, my lord, 19% have been granted.
Lord Sarkar.
Neighbor statement lordship, petitioner name transfer, they helping the police, others accused person to assaulted the police and obstructed their government duties. This is the allegation lordship. And lordship, total 9 victim lordship, or 9 victim injury reports are simple lordship. Out of 32 accused person, 30 accused person are all bail. As per the report lordship. 2 are absconding, WP issued.
WP is concerned. First of all, not being declared as a proclaimed offender by any competent court of law. Recently, my lord, in Asha Devi, my lord, I cannot recall properly, my lord, 2024 judgment. The Honorable Apex Court has very precisely stated, my lord, that my lord, issuance of WPA or my lord, declaration of proclamation, my lord, have no bar, my lord, either to my lord, anticipatory bail.
So what is the bar then? You are suppose a person is absconding for so many years. So where is the bar? He will come at any time and pray for anticipated bail.
Has to be declared as a proclaimed offender. Number one. Number two, here, my lord, only WPA has been issued. I have not been, my lord, declared as a proclaimed offender. In my lord, in twin conditions, my lord, the Honorable Apex Court has clarified that these twin conditions, my lord, the issuance as well as my lord, declarations have no bar, my lord, have no absolute bar. My name has not been, my lord, in the FIR. Co-accused statement, someone has been arrested, from his mouth, my lord, my name has been uttered, which has no evidentiary value, even, my lord.
The report filed by the state is taken on record. Learned advocate for the petitioner submits that out of 32 accused persons,
32 lordship.
30 have already been granted bail and anticipatory bail. There are no such specific allegations against this petitioner. He seeks for anticipatory bail. Opposing such prayer for bail, learned advocate for the state submits that the petitioner has absconded since long and already a warrant of proclamation and attachment has been issued. He seeks for dismissal of the bail application. Here use the case diary and materials on record. His name is Bharat Sarkar.
Charge sheet serial number 28 lordship.
It is found from the injury report that the nature of injuries are all simple. Other co-accused are also on bail. Fancy the above? Yep. Hello. Meet the IO once in a photo. আগেরটা কেটে দেবে গো। দরকার নেই, investigation complete. Charge sheet has been submitted.
Yes, lordship, charge sheet submitted.
ঠিক আছে, চলি।
Yes, sir, stamp for the same, Lordship. Last occasion, call for the report. Lordship, this. Yes, that too. Direct to the end. This is the report and the seizure list.
Yes.
Is the report favorable?
Favorable so far as this, he says the transaction has been made amounting to 5,79,000.
Yes, so out of 30 lakhs, already about 6 lakhs has been paid. On the last occasion, I had apprised your lordship about 2,79,000. Lord, later on, also, when we came to know that another 3 lakhs is also paid. So, the ingredients of the offense of port painting, those are not made up. The intention to deceive from the beginning is not there. There is a contract involved. At best, this can be treated as a breach of contract. For that, the repetition for the law and commercial. And Lord, I had also apprised your lordship that after Lord expiry of the period.
Where is the contract?
Lord,
Where is the contract?
Lord, it is the admission is there in the FIR itself.
No.
Had
Where is the contract?
executed the contract and handed over the original. Perhaps, Lord, there is a seizure in the case diary as well.
Yes, agreement are there, agreement.
During the hearing of the Lord last bail application, last anticipatory bail application, it had come up that the agreement has been seized. Lord, the fifth line from the top of the company. Agreement dated 22nd of January 2024.
Ashit is a guarantor.
Lord, no. Here we are for Joseph Khadi, Lord. He is the executor of the debt.
Rashid?
Ashit has been granted anticipatory bail. Subha Khadi has also been granted
They are the guarantors.
And Lord, I am Joseph Khadi.
As per the agreement, they admitted the huge money they have taken and they returned back the money within a certain, but they did that.
As per the agreement, they were supposed to return the money.
Yes.
So at the time of taking the money, was there any agreement?
Yes.
My lord, agreement at page 12. They have agreed, yes, we have taken such and such money.
In the month of January 24, the agreement was contracted.
And on the last occasion, my learned colleague friend submitted some documents that is online transaction. They admittedly returned back the money 2,79,000 as per their documents, but our report is there, my lord, as per the direction of the Honorable Court. The investigation officer, after investigating the all transaction, it revealed that 5,79,000 had already been paid out of 23 lakhs 95,000.
But where is the agreement by which the complainant has made a payment of 29 lakhs 85,000?
Yes, my lord. That is what I was telling you, lordship. My lord, we had executed the agreement and the original was handed over to the complainant. Perhaps, my lord, there is a seizure in the case diary. Agreement
Yes, active agreement. Active agreement.
বলে
দিয়েছি, page 12.
Page 12 of the case diary. As per the cost.
No.
And all
when was
the
this amount paid?
My lord, in the month of January 24.
24?
Yes, January of 24.
January 20.
January of 24, we received the money. We could not provide the employment. Ultimately, the check was issued in the month of December 24.
And all the payment has made within January to February. Thereafter, no
no.
further payment has been made.
I just want to know whether there was agreement in the month of January 2024 at the time when there was a payment made by the complainant.
Yes, my lord. The FIR itself states that.
Where is that copy?
Not the agreement that your lordship is saying, is it of the month of?
It is of the month of January 2025. When there is a mutual agreement between the parties that they will make payment. That's all. January 25.
My lord, the previous agreement, my lord, we also do not have a copy.
One agreement is there, my lord. That is at face value. No further agreement. We have no knowledge about that agreement.
He says that there is
whether there was an agreement or not.
My lord, if there is a mutual agreement on record, my lord, in the month of January 2025, that also, my lord, proves that there is no criminality to this offence. If they have mutually resolved to, my lord, compound this offence, and my lord, the payments are to be made, my lord will have to see, my lord, whether my custodial interrogation for this offence is necessary.
No, whether any case is made out 420.
Exactly.
He is parting with 29 lakhs of rupees.
Yes, my lord.
What is the authority of this petitioner
Yes.
to represent himself as a person who can get a job for the complainant in Canada on
Yes.
contractual basis?
My lord, he has such a history while he
Is
has-
the government, union government authorizes any person to act to just provide a job, to procure a job for a person
Or
in Canada?
registered company or agencies.
How do you represent yourself? That's why I want to look to the first agreement which was executed. What was the terms of the agreement? What was the representation made by the party?
Yes.
I mean the petitioner.
No, my lord. So far, I know this, my lord, petitioner. He has a history of providing employment to the people of the local area in Canada. Because, my lord will kindly appreciate, my lord, people from the Nepali community, which is also the community that this petitioner belongs to, they happen to, my lord, go abroad for my lord, odd jobs, like, my lord, working in restaurants, my lord, taking employment up in my lord, sanitary works, my lord, things like that. So this man, my lord, he provides such jobs to those, my lord, people. That is what he is in the business of. And, my lord, in pursuance of the same, he also contracted this particular agreement. Therefore, my lord, he has a history. It is not that he made any false representation or tried to deceive anyone. He may not be, my lord, possessing any license or any such, as your lordship is inquiring. He may be a middleman. But, my lord, the fact is he is in such business and he has been providing such employments to me. Or, my lord, getting them jobs in Canada and my lord, in the Americas. That is what I'm concerned about. Whether there is any deception or any misrepresentation it was not made, according to me.
Then you have issued checks which has been dishonored.
Yes.
Yes, sir.
And that is why NIA, under NIA Act, one
This is, my lord,
case has already been filed and
this is, my lord, to question that discrepancy.
that is
which I was
pending.
speaking about with the other. The check was issued in the month of December 20. Lord knows, my lord, the period to institute the complaint expired in the month of February. Till that time, my lord, they did not take any action. That discrepancy arose, the limitation arose. To cushion that discrepancy, my lord, in the month of May, they come up with this complaint. And in the interregnum, my lord has also seen that that mutual agreement was also, my lord, contract.
But how this is a civil dispute or contractual dispute?
Maybe.
You are representing before the client, that person, complainant, without any authority. Who is Robertson? Who is Robertson? A.T. Robertson. How many people?
Lord, some new characters are coming up, my lord, in this way.
Who has signed this agreement?
yes.
Joseph Khati, your client has. That's why. Who is Ashok Robertson?
Yes. He's a man of Joseph Khati. Obviously. And a presumption will come.
There is a palpable deceitful act. One after the other, the Robertsons are
They give assurance.
Yes, because of.
Hey, Ashok, but
My lord, give me 1 minute. My lord, just 1 minute. Just one more minute. Milord has seen Milord Ashit Khati was suffering from brain hemorrhage. He was admitted in Nepal.
He has been granted the benefit. This person is very much, that's why I asked you, what is the authority to receive 29 lakhs of rupees providing a job in Canada? What is this representation? Without any authority? And despite there being check been issued, those checks has been dishonored. This is again a deceitful act. If your intention was clear to have it, he has given a notice to you. Probably this has brought to your notice because the person to whom you have issued the check, he has placed those check in your account. You have received a message that this check has been dishonored or not paid.
Yes.
So what steps did you take?
No, checks were issued by my partner who happens to be in the same business, Ravi Tejas. Ravi Tejas had
one of the
had
guarantors.
not issued the checks.
No.
Ravi Tejas, he was another person.
My Ravi,
Milord, if my intention
code
was
is
such, I would
rightly
not have-
pointed
I
out
would also not have paid the amount of
under
6 lakhs.
what authority he
Milord,
took the
grants me a
money
protection, Milord, let me
and
comply
give
with the
assurance
Please, Milord, that much Milord can do.
to
Grants me
secure
interim
have a
protection,
job
at least let me Milord comply
in
with the
Canada.
notice possible. Milord, there is
Then
no
the advocate for
criminal
the
act,
petition
kindly-
submits that.
Under what authority?
Everything cannot be said to be a civil and contractual one. This is a deceitful act. Have some authority, then you provide it. So, the advocate for the petition submits that the petitioner deals with providing employment in Canada on contractual basis. Stop. The petitioner was paid an amount of rupees 29 lakhs 90,000 by the complainant. The complainant alleges that such amount was not paid back, nor job was provided, which resulted in filing of the FIR. In the meantime, some checks were issued. In the meantime, post-dated checks amounting to rupees 23 lakhs 95,500 was issued to the complainant, which was returned and dishonored with endorsement insufficiency of fund. Since the complainant failed to take legal steps within the stipulated period as provided under the Negotiable Instruments Act, he has lodged this frivolous complaint. Admittedly, certain portion of the amount has already been paid by the petitioner to the complainant. He seeks for anticipatory bail to the petitioner, for grant of anticipatory bail to the petitioner. Opposing such prayer for anticipatory bail, learned advocate for the state submits that as agreed upon, certain portion of the reports filed by the state is taken out copy in. Certain portion amounting to 5,75,000 has been 9,000 has already been paid. However, due to deceitful act of the petitioner, the complainant was misled to part with an amount of rupees 29 lakhs 90,000. He seeks for dismissal of the application for anticipatory bail. Admittedly, here is the case where materials on record. Admittedly, an amount of rupees 29 lakhs 90,000 was paid to the petitioner by the complainant who promised to secure a job in Canada for the complainant on contractual basis. It is also not in dispute that neither the amount has been paid back nor the job has been provided. Needless to mention that in order to secure the said amount, post-dated checks were issued amounting to rupees 23,95,500, which has also been dishonored. The facts as revealing from the materials on record clearly indicates of a deceitful act. Acha, sorry, Kiradin. During the course of hearing, nothing has been placed on record to show that the petitioner had any authority to provide for such job abroad in the in Canada. The facts as revealed from the materials on record clearly shows of a deceitful act on the part of the petitioner, which coerced the complainant to part with a huge sum of money of 29,90,000. In view of the above, I am not inclined to extend the benefit of anticipating in favor of the petitioner. It's rejected interim order if any stands vacant. Sorry, sir.
Great.
Next.
Seven,
I'm for the state, my lord, 17.
Petitioner?
Earlier occasion, there was petitioner was not present, my lord.
None appears on behalf of the petitioner. This is second application.
Yes, my lord.
So hail. No?
He handed two.
Sajidul, no?
Yes, my lord.
Sajidul 399.
Eyewitnesses has named him in the 164 statement, my lord. Material is there.
None appears on behalf of the petitioner. Nor any accommodation has been sought for. On the last occasion, that is 19th November 2025, the petitioner failed to appear. In view of the above, the application being CRMA 739 of 2025 stands dismissed for non-prosecution.
Or dismissed.
Dismissed.
Item 18.
None. Not clear. After received or before? After received.
Who is for the state in this?
Still, we are all ready, lordships.
18 to ready and ready that is ready.
Oh, yeah. 18 and 19 both, no?
Item 20.
20.
In this application.
Why? Learned advocate for the petitioner seeks not.
My lord, state is present.
Learned advocate petitioner submit that the petitioner does not intend to press this application. In view of the above, the application being CRMA 742 of 2025 and dismissed for dismissed and not pressed. Dismissed as not pressed. Joy Ma. 46. Who is for the state?
I'm for the state, my lord.
I am a stockholder and selling SIM card. And there is one SIM card was issued in the name of Vishwajit Varman. And therefore inquiry that Vishwajit Varman denied that this SIM card was not issued to him. This is the allegation. Saying that when I not in the Vishwajit Varman not sponsoring this SIM card, but issued in the name of Vishwajit Varman. Kindly, victim complaint, last paragraph number, victim complaint, last paragraph. Last paragraph, first paragraph, thereby somehow managed the mobile number worker with the Vishwajit Varman and contacted with him over telephone. He stated that he neither applied for the SIM nor any knowledge about the same. Thereafter, I asked him to submit a written undertaking regarding the ownership of the said SIM number, but he certainly denied for the same. But the police authority called to the Vishwajit Varman, but he not saying, but only over telephone. This is not in my name. But he denied to even in a written declaration that I not applied for the SIM. This SIM was.
Who is this person? Who is the petitioner?
I am the Rakesh Varman. I am the sales officer and selling the SIM card to the people. This is my proposition. And allegation of SIM card of Vishwajit Varman was issued. No, Vishwajit Varman did not apply, but Vishwajit Varman denied that I not applied for the SIM card.
That will come later on. What prompted the police authority to contact you?
My submission.
Meeting was convened police commanded. Discuss the issue generation of SIM cards by various US agents. Following this memo, received guidance content and this meeting. 8 SIM numbers. To be done, there is said we should only have a simple value number than a staying at angle against long. The one that is the one of our four is straight one. Contacting your telephone. Yes. Yes. How many of these have been issued?
My specific instruction he applied. Or the reason like to my written in undertaking to the
When was this issued?
earlier.
Yes.
This present petitioner, he is He was involved in issuing fake SIM cards, my lord, and he was involved in acquisition and distribution of those SIM cards which have been misused for cyber fraud, my lord. This is a very serious offense, my lord.
How many of them are there?
FIR has been. No, my lord. Investigation is going on. Investigation is going on, my lord. And this is the list of the. To the list of the agents, my lord. He is one of them. Lovely. Statement.
Nine one two. 912. Yes. Any other thing?
Investigation is going on.
Possibly further. And during such inquiry, it has come to fore that several agents in the district of Kuch Bihar. All these are from Kuch Bihar. Kuch Bihar. Kuch Bihar, including the petitioner, are involved in issuing fake SIM cards which are being used for other offenses. The investigation is still under process. Peruse the case diary. She seeks for dismissal. Peruse the case diary and the materials on record. From the list annexed to the letter of Superintendent of Police Kuch Bihar dated 7th June 2024, it is found that this petitioner has issued several SIM cards which requires further investigation. It has to be inquired. You have to be the person namely Bishwajit Bormon, whose name the SIM card, namely of mobile number 6294531912, has been issued on being contacted, has stated that no such SIM card has been issued in his name. This requires necessary investigation. Considering such nature of the crime, rejected. Just reason না করেন একটা লাইন লিখে দেবেন, extend the benefit ওরকম করে দেবেন, extend the benefit to the petitioner, not inclined to extend it next. ওইরকম করে সাজিয়ে নেবেন এটা। চল নেক্সট। An advocate for the petitioner seeks not to phrase this application. In view of such application, dismissed as not. Next. Nijanur. Is for the petitioner.
Chassis submitted, my lord. Scalp injury is there.
Monday তে আসবে। Not today.
Not today. Wait for today. Not today.
ডেটটা ইয়ে করে রাখবো, নট টুডে হচ্ছে ডেটটা দিন।
My lord,
Right. Who will conduct this case here?
Yes,
Who will conduct the case here?
will be conducting a court.
Ask her to join.
my lord,
She has come. So whom you are calling then? Who will conduct this case? Gina Rudro or who else? Anybody in the circuit bench? She will conduct the case. Ask her to join online.
my lord, I'm praying for not today, my lord, in this
Fine.
matter. Mr. Ujjwal Laksam, he will appear in this matter, my lord, but he had to leave.
Yeah,
So-
not today.
Grateful, my lord.
My lord,
Yeah.
in 20, my lord, My lord, in 25, my lord, Mr. Omuleshwar is appearing for the petitioner, my lord. My lord, on his behalf, my lord, I'm praying for not today, my lord.
দেখি সার্ভিসের ব্যাপার আছে দেখো তো
No, no, my lord.
But I have also seeking for a time, but I have to prepare myself as because just now I received the case diary. It's a voluminous case diary. Though interim protection is given by the earlier
Yes,
bench,
my lord.
but subsequent development I have to check, my lord.
what are the sections?
My lord, section, sir, 3. My lord, in IPC, my lord, 477A, 468, 420, 409.
ঠিক আছে
Monday, Monday.
Monday, my lord.
yes
Grateful.
My lord, I'm grateful to your lordship, my lord.
For the state.
Not to this, the petitioner already arrested.
16th
The
of
advocate for the petitioner submits that the petitioner has already been arrested and as such this application has become infructuous. In view of the above, the application being CRM 751 of 2025 is dismissed as being infructuous.
I'm for the state, your lordship.
I am appearing for the state.
I'm for the state.
27.
What are the sections?
Oh, 27, sorry.
Unju withdrawn. What are the sections?
Sections, my lord,
108.
108 BNS corresponding to section 306 IPC. Abetment of suicide.
306.
306.
Next.
I'm grateful to your lordship.
I'm for the state lordship.
I am changed from effective, but who don't go to it's out of session due to medical.
Lordship, 22nd July 25, it was rejected for 38 application. Page 8, lordship, petition.
What is the concern of the birth certificate?
Yes, sir. Report produced, lordship. The report says that this is the fake report, lordship.
This petitioner is the block development officer. Who is this? Who has issued that?
Dinhata municipality. That no birth certificate was issued in the memo. Big person.
Abdul Habib.
Saddam Mia. Birth certificate of Saddam Mia, the present petitioner, lordship.
He produced a birth certificate which is fake.
Yes, lordship. The report is produced. And it was earlier lordship considered and rejected, well petition.
Then Give the case diary.
This is the report, Lordship.
Why? So you go through the records. What is the change since July 2025? What is the change in circumstances? Otherwise, dismiss the
No change in circumstances. Before charge sheet pending, before charge sheet was rejected, charge sheet pending.
No. You want this will appear on Monday. That much can be done, not next circuit. This is a second application. Who is the conducting advocate? He has not come today. You go through the records and make your submission on Monday. You need to take Monday तरफ. Order of?
Your Lordship, I'm appearing on behalf of the de facto complainant, Your Lordship.
What is this case? Who will conduct this case? Who will conduct this case? Monday. Monday. Who is for the state?
Mr. Nila sir, and grab up the street.
Diplog.
Yes.
Can I see that?
Party section is one the line of activity model. So big patch of the case is one of husband and wife problem. Wife did the matrimonial house after 1 month of marriage, and both the family after both the family decided to seat before the local ground panchayat and legal settlement. And amicable settlement takes. And after that, when the family, which is bride's family, went to the house of the Fruits family, went to the house of the bride's family. The relative of bride is brother of the group. This is the issue. Now, all the father is the defective law, the constitution against all the members of the bride family, and all the members of the bride family.
Who is this person?
He is the younger brother of the bride.
Younger brother. What is the injury?
Yes, yes, my lord. Kindly peruse, my lord, page 17 of the case diary, my lord. This is grievous injury. Multiple injuries, my lord. Moreover, my lord, charge sheet is pending, my lord. Investigation is still going on. And 164 statement is there, my lord, where the present petitioner name is transferred as my lord.
Which is the statement?
164, my lord, page. In all 164, but no, 161.
No, can I
Get back?
It been
I don't think and it's the FIR, the people are spending the FIR, that the present teacher were as well as who was present as many others who may not have been transpired here.
Biplov and Biplov.
Nothing, even 161. দেখো না অরিজিনাল কেস এটা আছে এটা সার্টিফিকেট আছে
Who is the complainant? Who is the complainant?
কমপ্লেন my lord mother of the Ratna Burman 492
Ranjan.
এটা তো
161. Oh, no, no, it is 161.
161 my lord
No, 161.
all the 161 statement my lord no 164 my lord page 5 9 10 and 11 my lord page 5 9 10 and 11 my lord এখানে 164
Money. Statement of the victim has been recorded? No,
my lord charge sheet is pending
not yet recorded.
not yet recorded man
The initial stage of investigation, that case of August 2025, just August 2020.
Learned advocate for the petitioner submits that the dispute between the parties relates to family dispute. There are no specific allegations against the petitioner.
সাদা
One more thing.
আমাদের দাম নেই
Yes.
আমাদের ছবি কই
Ranjan, yes.
Page number 10.
Alright, okay.
Talking of the other activity. That bride also will indicate this matter. Bride will mother.
All have been granted bail.
Page number 3 of.
This is 439 bail application.
Anticipatory bail application.
Page number 11.
Vipula Seva. The other co-accused have granted anticipatory bail by the learned Sessions Judge. Seeks for anticipatory bail. Grant of anticipatory in favor of the petitioner. Learned advocate for the state, learned additional government pleader for the state opposing such prayer, submits that the petitioner is involved in the alleged offense of assault, which resulted in grievous injuries to the victim. The victim was hospitalized. Stop. He seeks for dismissal of the application. Here is the case and materials on record. It appears from the injury report that the victim sustained lacerated injury and cut injury on the upper lip. Lacerated injury in the skull by sharp cutting weapon, knife and metal rod. Like such as knife. On being assaulted by knife and metal rod. The nature of injury has been noted to be grievous. The victim has named this petitioner as his assailant. The victim had to be hospitalized for his treatment.
Grateful.
I am grateful, Your Lordship.
Next. Admission. Interview.
Article number 149.
Who is coming? विश्वास और नहीं तो अनिरुद्ध विश्वास नहीं तो स्टेटस राफा पास हो गया और रिविजन्स को देखे तो मोशन है oh yeah where is Mr. Vishwas wait for some time pass over from Rakas Aniruddha Vishwas hai
Item 150.
Mr. Vishwas is there in the appeal. You have given the copy to me? Yes. You just wait for some time, let him come. Next. Mr. 150. Mayank Roy. Who is for the state in this 513?
Not hard, my lord. One. 151.
Only one, yeah, or what, all on motion. All on
This criminal motion, my lord.
So who is, Mr. Roy was there. Vivash Kumar Nandi appeared for the petitioner. None appears on behalf of the petitioner. Just a minute. None appears on behalf of the petitioner. ওনার নাম তো বলো তো, ওনার জুনিয়র ছিল মায়াঙ্ক রায়। কবে দেবর, ওনার নামটা কি বলতো? চোখে দুটো চুল আছে তো, যিনি মুভ করছিল। মায়াঙ্ক রায় মুভ করছিল না কিছুদিন আগে, মায়াঙ্ক রায়। গেল কোথায়? এ তো অ্যাডজমেন্ট নিয়েছে, 21 তারিখ পড়লো, আর সার্কিটই হবে না। তেরো 11। Only none appears on behalf of the petitioner for ends of justice. The matter is adjourned. Is this matter next week at due room? কি ছিল ওটাই? কি ছিল ওটাই? নীলয় চক্রবর্তী বললো না, বললো তো নীলয় চক্রবর্তী। ভুল আছে, দেখেছেন? দেখি ওদেরকে বলবো, ডাকবো জাগৃতি মিশ্র।
My lord, I am for the state in this matter. My lord, here is the report, shows that the appellant number 1, Bimal Mojumdar, he passed away while in custody. Here is the report, my lord.
Yes, his name will be expunged.
Yes.
His name will be expunged. Now you are moving for
Rest 2.
Respect of appeal number
2 and 3. What is the conviction?
condition under section 302, 307, and 26 of the Indian Penal Code. The term imprisonment 5 years, 300 conviction under section 307 and sentence for 5 years imprisonment. It has been passed, and for charge of section 326, it is 1 year imprisonment has been
5 years and 1 year. 5 years and 1 year.
Yeah, 5 years and 1 year, both are to run concurrently. So this is the thing I have. This is the condition that I have challenged in another which I in connection with that I have made for application of separate. Now I am doing a fact of the case. The petitioner's allegation was that according to the FIR is that the de facto complainant's wife on 10th of September 2022 at 1 a.m. morning, while going to open his pawn shop at a particular area of Mollik Bazar garage field. At that point of time, allegedly the affair number 1 who has died now, and the affair number 2 and 3 all had in conspiracy together. They have went after her and they hit to his wife with the help of a stone. And she immediately fell down and covered with the blood. And subsequently, they were taken to and the accused individual threw her into a river nearly 20 feet from the beach. So that moment, thereafter she was rescued and she was immediately taken to hospital at local hospital at Lotabari hospital, and where she was treated, and thereafter she was subsequently referred to district hospital at Alipurduar. Alipurduar. This is the whole sum of the case. Now, during the course of investigation, the petitioner number 3 was arrested. Petitioner number 2 was also arrested, and the petitioner number 1 is also arrested. Now, thereafter, during the course of investigation, admittedly, there is no 164 statement of the victim was ever recorded. Number 1. Number 2, the medical report was also done upon examination of the victim lady. That is also produced in the trial as an exhibit. Subsequently, the charge sheet was submitted under section 306, 326, 307, 341 and 34. And all this, the delegation was taken cognizance of by the learned trial magistrate. Subsequently, the matter was committed. Trial court, after examination of all the witnesses, pleased to hold that all three are pleased to that are guilty for offence so and so. Interestingly, during the consideration of framing of charge, however, the charge under section 307 and 326 was framed, but there is no charge. So, sorry, there was a charge under section 341 also. But interestingly, in the impugned judgment or judgment of conviction, there is no whisper regarding the charge under section 341 or 341. Whether all accused persons are on discharge or convicted is completely silent. The learned trial court had dealt with in such a fashion. However, so now the petitioner, the one significant aspect is that the petitioner number 3, who is the eldest, who is the youngest son of the petitioner number 1, appellant number 1, who is the innocent person who was undergoing treatment since 2019. That factor was perhaps brought to the London trial court, but that the aspect has not been dealt with, which is complete violation of the fundamental rights, because there is a specific provision under the chapter 14 of the of the Code of Criminal Procedure, where all the unsound mind or innocent accused person to be dealt with in terms of the scheme of the law. But interestingly, none of the court, either magistrate or even the learned trial court, did not deal with this issue at that point of time. However, I have raised this issue in my appeal. Lawsuit can be taken. This is the second position of law that an innocent person, when put to face a trial, and when he was found an innocent, so entire trial goes against him. So at this juncture, the petitioner number 2, that is the youngest son of the deceased accused appellant, has already suffered 3 years, more than 3 years imprisonment out of 5 years. So his release is immediately as a judicial importance to be for the ends of justice.
Who has?
Total Mulinda, petitioner number 2.
Choton was not granted bail.
Choton, no. Choton Mulinda.
Choton was not granted bail.
3 years on custody. More than 3 years.
After conviction.
No, total.
He was never on bail.
No, never. Even I have categorically heard from the concerned person that even the custodial date of her father in the jail commission, she was found a very unresponsive. It's a very bizarre attitude to her that he doesn't feel it. He doesn't feel it.
Who will submit a report with regard to appellant number 3?
Madam.
With regard to what he has raised a ground that he is insane and that has not been considered by the court. Let a report be submitted by.
There is no reflection about his insanity, my lord. Not a single sheet of paper was exhibited regarding his insanity, my lord.
You have placed any record?
At this stage, plea of insanity at the appellate stage. Otherwise there is overwhelming evidence. injured witness is there, my lord. She has categorically stated his role and contribution in the commission of the offence.
No, he says that he has placed this argument before the court regarding appellant number 3 being insane.
My lord, the argument can only be placed when it is supported by some document, my lord. What is the DW? Where is the DW? Where is the doctor who examined him?
And any ground taken in the appeal?
Yes, I have taken.
Which paragraph?
In my CRAN application.
Not in the main appeal.
Main appeal also.
CRAN appeal.
CRAN application, I have taken out that ground in para. Can you see?
Not CRAN. What is the ground? You have taken
Para
the ground in the appeal.
Para 2.
In the
Appeal. Bring the appeal.
I have taken out this ground on the basis of the document by annexing the document also in the CRAN. I have attached all the documents, necessary documents.
Whether any document was exhibited during the trial.
I believe that I'm not sure, but perhaps it has not been shown to the
So now at the appeal stage, how can you claim it?
That's why insanity plea can be taken out.
Additional evidence has to be taken for that. Is another long process.
That's another different issue. So
And there is no specific application for 391.
I am relying upon that an accused person is all along under treatment since 2019 under the doctor with the doctor specialist, and he was insane. And I am relying upon that the injured person cannot be forced to face the trial. So consequently, the conviction, so far the conviction is concerned, is completely illegal against him.
During the trial, whether this was brought to the notice of the court with a document,
yes,
or by examining a psychiatrist. This is my question. Any DW? Did you examine any DW, sir?
What is his name? What is his name? What is his name?
Choton.
Choton is the son, or the appellant number 3 is the son?
No, Choton Mujumdar. Appellant number 3.
কোথায় annexure কত তোমার?
This is the best, but the best favorable evidence in my favor also can see the injury report of the deceased. So for the bail payer is concerned also that the 307 charge is not maintainable because there is no such previous injury.
Let us first see the medical document.
Yes, sir. At page 17 onwards.
Of the crime.
What is this? He has been sent to the rehabilitation center.
Page 17.
Was he addicted to some drinks or something of that sort?
I don't know, but there is she was treated under the mental health hospital at Assam, Tejpur.
When?
Page?
When?
There is a discharge certificate that is on 28th of May 2024.
28th of October.
Yes.
Which
No,
page number?
28th of May 2024.
Page number.
17, page 17. Of my CRAN application.
It's a 2022 case, my lord.
Prior to that, Lordship.
My lord, if he remained in custody all along, then how could he move to Assam for a treatment?
Can you see?
He is himself.
Can you see? Then page 19.
He himself is presenting a paradox.
Then the page 17, page 19.
When was the case initiated? 22.
22, my lord.
Mr. Saha, you were on bail.
Definitely he was on bail. Had he not been on bail, how could he, how had he gone to the mental hospital for a treatment? It's misleading the court here. It's leading us to a farrago of distortion, my lord. Nothing more than that.
One by one. Then can you see page 19, where there is a.
Were you on bail during trial or not?
The petition number 3 was not. I have an instruction that petition number 3 was.
Find out. Then how come this 24th certificate is being carried? How he is discharged from the hospital when he was in custody?
I believe that he has, it was sent by the hospital, by the jail authority.
But why would they send him to Tezpur, a different
Then
state?
there
my lord?
has to
We
be an
have
order of the
medical
court to send
facilities
the
in
accused
Bengal.
from the custody of a particular jail to Assam for treatment. There has to be an order of the court. How can he be sent?
The learned trial court has recorded.
Sir,
that-
kindly go through the records or you withdraw your submission that he was on bail, he was not on jail, not in jail during trial. That can be considered. That there is a mistake on your part, that he was on bail. You find out. Because there cannot be a person who is in custody cannot be sent to Assam without the permission of the court.
So that I have to withdraw the submission, that I have to take a fresh information.
Yes.
Because I have a specific.
Because see, there is a your plea is that 5 years have been given, 3 years already he is in custody since arrest.
Yes,
And now the document says that in 24 there was a discharge from a hospital.
yes.
How this can be made a person who is in bail, on jail? How
Take instruction for that, number one. Number two.
take instruction and come back.
This is extremely paradoxical, my lord, this submission.
On the prayer of learned advocate for the appellant. Affidavit you have filing today? Affidavit of service filed on behalf of the petition is taken
No,
on
let the
record.
discharge order be passed. Let the appeal for appellate number 1 appeal be aborted.
Expunged.
Expunged.
This is report you are filing, Mr.
Yes, my lord.
Report filed by.
Yes, yes.
Filed by the state in compliance to the previous order dated 29th October 2025 is taken on record. On the prayer of learned advocate for the appellant. Obviously. Monday, second up.
My lord. Lord. My lord, same order may be passed in the CRAN. He has to be expunged from the CRAN also, my lord.
Huh?
He has to be expunged from the CRAN application also.
Huh.
Another
As per
order in
the-
the CRAN.
The report of the state. His name is convict Bimal
Bimal Majumdar,
Majumdar alias Majumdar এর নামটা দেখে নেবে না Majumdar alias
Must have been
Majumdar
while in custody.
expired on the night of 26th October 2025 at Jalpaiguri Medical College and Hospital. Subsequently, Kotwali Police Station, Jalpaiguri registered an unnatural death within bracket UD case number 711 of 2025 dated 27th October 2025 in this regard. In view of the above, the name of the respondent, appellant number 1, Bimal Majumdar, DAR, and Mazumdar, MAZUMDER, is expunged from the array of the appellants, both in CRAN as both in the memorandum, both from the memorandum of appeal as from the CRAN.
Being abated.
As being abated.
Being abated.
তো ইনফর্মেট গন্ডগোল হয়ে যাচ্ছে অ্যাপিলটাকে অ্যাডমিট করে
অবলাই করছে
ঠিক আছে অ্যাপিলটা দিনে বলবেন অ্যাডমিট করতে হবে নেক্সট ডাকুন হ্যাঁ বলুন থাক ভিডিও নেক্সট Who is for the state?
You copy not submission.
ওই সব মোশনের তো কপি সার্ভিস হয় না না?
All are motion panel. There are 156 also.
এগুলো নট টুডে করে চলবে না দেখি কন্টেন্ট
156 panel copies there.
নেক্সট এই অল জাস্ট নট টুডে একটা নোট করে রাখবেন নেক্সট ডে তো দেখে নেন নেক্সট দেখো
156 copies there.
আপনি সিরিয়াল ডেকে যান সিরিয়ালটা যদি না থাকে নট টুডে করুন নেক্সট নট টুডে নেক্সট
One 126, 15 to 51 to 25 of AS. Read with section 3(1) RS of middle class, children class and children race, prevention of atrocities. But before going to my arguments, let me encapsulate the contents of the FIR. But my FIR is annexure A. You will find the formal FIR, right? Page 13. And page 14 is the written complaint. This complaint and this petition, the complaint that is respondent number 2 and the petitions, both of them reside in a same building. Now this petition, this respondent number 2 are students who are staying at the ground floor and the petitioners, they're staying at the top floor. Now, my lord, what happened is that on a fine day, these petitioners, they visited the ground floor and started hammering at the windows of the respondent number 2. And when they came out and asked this petitioners to why they are doing such activities, they started a quarrel. And during that quarrel, you will find in paragraph number 3 of the FIR, where the atrocities part mentioning of backwards horror, that is written in bold.
He did not read that.
Yeah, no, I'll not read that. Just that there is a word that is Nepali. The term that has been used is Nepali. And the rest are now my argument, I'll press my arguments on the point is that, my lord, there is the community Nepali. Nepali is not a caste. It is not a caste which has been scheduled in the Constitution of India as any scheduled caste or scheduled tribe. Nepali as a whole is a citizen of Nepal are considered as Nepalis. Or the people we often consider the people who speak Nepali, or previously their ancestors used to stay at Nepal as Nepalis. Now, my lord, this is the part where I submit that no prima facie ingredients are there in the complaint itself, which shows that there has been any commission of offense under the atrocities section. Because for attracting any of the sections of the atrocities act, any of the sections, what has to be considered is the uttering of the caste and defaming or humiliating someone with the what they do or previously their caste or tribes used to do, that sort of humiliation. But from the FIR or the contents of the FIR, you will easily on their perusal, it is very much evident that there was a quarrel, just a quarrel between the residents of the same apartment, and during that post of quarrel, there was no intention that I'll go and I'll just humiliate them, that you are such and such and you do such and such. There was a quarrel, and during that quarrel, such things came out. And assuming not admitting the fact, if such words has been uttered, such words doesn't constitute any of the offense under section 3(1) RS of the Atrocities Act. Now, my lord, I'll just bother you with two judgments. I'll just read out two paragraphs, two, three paragraphs, my lord, of the Honorable Apex Court. My lord, first judgment I am referring to is Hitesh Verma versus State of Uttarakhand. My lord, the relevant paragraphs are para number 10 and para number 18. Now, what does para number 10 says? The act was enacted to improve the social economic conditions of the vulnerable sections of the society, as they have been subjected to various offences such as indignities, humiliations, and harassment. They have been deprived of life and property as well. The object of the act is thus to punish the violators who inflict indignities, humiliations, and harassment, and commit the offence as defined under Section 3 of the Act. The Act is thus intended to punish the acts of the upper caste against the vulnerable section of the society for the reason that they belong to a particular community. Now, here, my lord, there is nothing in the face of the FIR which shows this last portion that because they belong to that particular community, I went and started doing what has been alleged in the FIR. Now, the next paragraph referring to is paragraph number 18, my lord.
But they are scheduled tribes.
Yes.
They are tribes.
They are claiming that they are tribal, but they have not mentioned as to which tribe they belong to in the FIR. In the FIR, they have just mentioned that I belong to a tribal community.
Then you have the act.
Yes.
Does the act define what is scheduled caste and scheduled tribe?
The scheduled caste and scheduled tribe has been described in Article 341, Article 342 of the Constitution of India.
Okay.
And there, Article 341, 342, explains that who belongs to scheduled caste and who belongs to scheduled tribe.
C21. Yes. Because they were sitting next. Page number 8 is not this.
Page number
8.
8.
Scheduled caste. Scheduled caste and scheduled tribe is as defined under 2(1)(c) of the Scheduled Caste and Scheduled Tribe Atrocities Act. Now, in your book, the page number 8, 2(c)(1) is missing. দেখো ওটা বিয়েতে থাকবে। Where from I get it? It is not there, sir. Page 8 is not there.
Section 3 and I am my book is not the last and I am managing a short pass for I'll arrange one next on the
Monday till top it up. Dekhe asho. This is your only contention that Nepali is not a.
Nepali.
That is your only contention.
Citizens of Nepal, their ancestors.
এই জাজমেন্ট এখন দিয়ে দাও মানডেতে, এটা টপের দিকে আসবে তো। সুজিত বাবু অ্যাপিলটা আগে দিয়ে দেবে, কে নিল অ্যাপিলের ডিপ্রেশনটা? মানডেতে আসবে তো।
Item 154, next item.